So I was.
Of course, sir, but there was a little bit of delay also, so we thought we can
No,
extend that.
that's all right. Yeah, so that's what I'm saying. You want me to talk about for what, 20 minutes and then we take a Q&A, or you want me to talk about for 30 minutes and then we do a Q&A?
As in, whatever way you would like to go, sir.
Sure.
20 30 minutes would be great. We are live, sir.
Sure.
30 minutes.
Yes.
Okay, sir. So good evening, one and all. I am Vineet Singh, and I'll be hosting today's event. This illegal festival is organized by the Students' Organization Democrats under the aegis of the lovely professional university. And our today's topic is legal complications. For today, our guest is Dr. Vikas Balia. Dr. Vikas Balia is also an eminent advocate and a qualified chartered accountant with a passion for sustainable living ideas and a wide exposure to several areas of law and finance. He also founded the Desert Leaf Foundation. Thank you so much, sir, for your presence here. And without further ado, we'd like to proceed with today's webinar.
Thank you, Vineet. It's always been a pleasure to speak to students and faculty alike, and lovely to be introduced to the lovely professional university. Very interesting title that you've given in and to your organization as well as today's subject. Let me talk first of the today's subject, which is legal complication. We've always thought, and this has been an anecdote or a kind of a law that's been going in the physics world, but it's equally applicable to each and every subject. And it says that if you can't explain it to a child, it isn't science. And the variation goes that if you can't explain it simply, you don't understand it well enough. And, depicting on the weather or the mood, this has been attributed to right from Albert Einstein to Richard Feynman, who has said this. But the bottom line is that if you can't talk about something in a very simple manner, if it can't be conveyed very simply, it's possibly because you do not understand it very well, or you've not got your clarity of thought. Unfortunately, the legal world has moved away, and every day it's moving away literally at the speed of the light from simplicity to being complex, because we are just unwilling to see and imbibe the first principles or go by rationality and logic. So that was one. And I wanted to sort of connect it to the other, that your organization is, or your bunch of people are Democrats. And what is democracy at the end of the day? What distinguishes between a democracy and other form of governance is essentially two things. We always talk of that. First thing is that the role the people play. And mind you, I'm not talking of elections. An elected government could be very different from a democratic government. They are two independent things. We have of late started talking and thinking in terms of an elected government being equivalent to a democratic government. So that is one. But in terms of governance policy, what really distinguishes democracy from other forms is the role the courts play and what law play in governance. So there are multiple, there are many ways of distinguishing different kinds of courts, but for our purposes, let me distinguish into three kinds. You've got criminal courts, which essentially look after the criminal governance or the way to control law and order in the place where the government is in place. You've got civil courts, which essentially decides, advises, adjudicates on civil disputes between people, one person and the other, or it could be between people and the government, because government plays a lot of role in civil matters as well. You can have a contract with the government, but so there it is a contracting party. So you may have a civil dispute with the government. But it's the third form of courts, which are the distinguishing feature of a democracy. That's the constitutional courts. Constitutional courts were traditionally or originally designed to do three functions. One was to advise the government, second was to interpret the law, but it is the third and the most important role which, under any constitution or any governance or democratic governance, a constitutional court has to play, is protection of the citizen against the government. And this is not in the sense of a negative thing that the government is against the citizen. It is just a layer of protection which is provided so that the government may not override the citizens. Unfortunately, what we see happening around the world is that the courts are more and more becoming, constitutional courts are more and more becoming the defendants of the government against the citizen. The role has virtually sort of turned around. Now, that is a dangerous sort of a territory that courts may tread upon. And that is a large reason for this has been the complexity that we have created. And that is why I wanted to combine the two things to see that how, you will need to address legal complications that will come up. And there's always a paucity of time. So today I will look more at the procedural side, but I just wanted to sort of lay down the larger philosophy which one needs to understand to really know why legal complications could be disastrous. Not just at an individual level where you're looking at redressal, but at the level of governance where the roles of the court could be compromised. And without any agenda, it will happen gradually because of the complications that keep coming in. Um, let me just sort of jog us as students who've all been studying that what is the role of a lawyer? Yes, we do cases for our clients, or we advise them, or we do transactions for them. But at the end of the day, what is it that we are for as lawyers? We essentially provide a solution to a grievance, to an injustice, to a problem that is faced by an individual or a corporation. Could be anyone, or could be the government. Now, when somebody comes to you with a problem, that this is my grievance, this is the injustice that has been carried to me, this is where I am facing a problem, this is where I got stuck. What do you need to find? You find a possible remedy for him. And the remedy that you find will essentially decide the course of action which the person would undertake for his redressal of his grievance. For the purpose of simplicity, I'll just refer it to as a grievance. I mean, it would mean all of the things. But that itself, suddenly, I mean, if you're a practitioner, you know, the problem as a practitioner begins at just that stage. How do you find the appropriate remedy for the person? Even if you understood the grievance, you understood the problem he has had, how do you address or how do you take him to the solution? Because that is where you suddenly find that our legislative possibilities that have been created with different acts, with different opportunities for redressals being given in, have itself become so complex that it's difficult to find the correct way forward. And that is where a whole lot of a litigation is still stuck. So let me clarify. So first thing is, which is the kind of remedy you will go in for? You can file a suit. There is a kind of remedy which is provided under writs before the constitutional courts. There are certain places or certain subjects. There are references provided for. Somewhere there's an appeal provided for. Somewhere there's a revision provided for. Somewhere there's a reference provided for. Somewhere there is a settlement provided for. Somewhere there's an arbitration provided for. Why would you pick one over the other? And more often than not, you really don't have a choice. The law provides for only one remedy that is available to you, and you find that you are stuck in how to find that remedy for you because a lot of them are overlapping. When theoretically somebody writes the different remedies, is very different from practically when you come across actual situations. where one could be overlapping with the other. And as a citizen, how am I bothered whether a suit has to be filed or a revision or a reference or a writ petition, as long as I get my redressal? It's been a playground for lawyers, judges, and the legal fraternity, where they have virtually gone into finding the nuances and subtle distinctions between one and the other, forgetting in the process that it's all at the expense. And I just don't mean the monetary expense, but expense every which way of the litigant or the person who's seeking that advice or the person who's seeking the justice. Now, just see, the problem doesn't end there. The second problem is which forum to go to. Do I go to a civil court? Do I go to a tribunal? Do I go to the high court? Do I go to the government who has established multiple boards or has established authorities? Which one? Because what has not been created and ought to have been was that I go with my problem to one place, and it may be the authorities who will decide which forum and which remedy. But that onus has been virtually left on us. And once we decide that, then it is open for the authorities as well as the other side to contend that there is no that the option that you've chosen is incorrect. So the classic case, Biniti, am I audible? Because I see that.
Yes, sir. Sir, you are audible.
Sorry. The debate starts therein, and I don't know if anybody has had the experience of looking at the pending matters in the country or the length. A large part of those matters are still stuck in the question of jurisdiction, that where the matter will go, or the remedy that somebody has chosen, whether you can file a suit or a writ, because you can't do multiple things, and nobody is going to advise you correctly. On a lighter side, we've always said that ignorance of law is no excuse. All of you would have heard that or read that while studying law, that everybody is supposed to know the law. But interestingly, there are only two kinds of people for whom ignorance of law is not an excuse. I mean, is an excuse, and they are not punished for it. And they are the only experts in the field, the lawyers and the judges. So if a mistake is made by them on law, well, you file an appeal or you go to another lawyer, but there is no penalty on it. But imagine a citizen, he doesn't know the law, he's penalized for it. And he's not an expert on law. And this has been a case, this has been classic problem for the complications that have arisen because of the very complex legal system that we have structured, which possibly is not required. The third is the territorial jurisdiction issues we come in, that whether it is going to be filed here or not. As you go along, you will come across a lot of international arbitrations and international cases where more than half the fight is on where the matter would be, which law would apply, and where would the redressal be coming from. Possibly that has happened because over a period of time, we've stopped trusting people and started laying down law basis the exceptional situation which arises, because it's only the exceptional person who goes to the court. 99 of 100 times when things happen normally, you don't have to go for redressal, you don't have to go to court. Only when an abnormal situation arises and you are in trouble, or maybe not in trouble, but there's an interpretational issue, you go to the courts. Now, what is before the courts at that stage is that exceptional situation. And basis those facts and exceptional situations, you end up laying down the law. When a law is laid down for an exceptional situation, it addresses that situation, but it creates trouble for the 99 out of 100 situations which are very normal. So what happens in the process is that you provide a legal system which has become so complex, which is beyond the comprehension of a common man. So when we talk of complex things like intellectual property law, or could be securities law, etc., why is it that only the lawyer and the judge should understand that law? the common man or the person who's going to use that domain or that subject, the person who's inventing something really doesn't understand intellectual property law. Now it's a kind of a such a sad situation that a law which is built for the protection of an inventor, the inventor doesn't understand the same. A law which is built or for the protection of the farmer, he doesn't understand that law. Now that complication, is that the desirable law? Because John Rawls, the famous jurist, said in his theory of justice, the way things are does not determine the way they ought to be. So we have to, right from when we are studying and when we enter into the profession in different phases, we must always try to find out the simple first principle and see what the law ought to be and what it is, instead of trying to see it in a very complex manner. Let me give you two examples, and both are sort of three examples. All are sort of used now as part of teaching methodologies. I don't know if you've heard of the Cobra effect. It's a very common, and today you'll find it, in today's world, roaming around on the WhatsApp. What is the Cobra effect? But there's a very interesting piece of governance dating back to the British period. In fact, the early periods of the British, where they were all scared and afraid of the menace of the snakes in the capital and in India. So they came out with a policy which said that anybody who catches a snake, and they considered India, was always considered a land of snake charmers and somebody who played with snakes. So they said that this is a policy that we'll give an incentive and will reward anyone who comes and brings a snake to the authorities. So that they thought that they will, eliminate all the snakes. In some time, they found that there have been a lot of people who started breeding snakes because they just wanted to earn money out of handing it over to the government. So instead of less snakes, now you've got more snakes, and the people are going to sort of game the system and earn out of that problem. But the real problem didn't end there. When they sat back at the policy level discussion meet, they figured out that, okay, the incentive hasn't worked. So let's crack the incentive. So from now on, there would be no payment for any snake that has been brought in. The minute that happened, all those people who were breeding snakes just let them go in the outside world, because now they had no economic utility for the same. So at the end of the whole process, you had more snakes than to begin with, A. And the principle that we derive out of this is that if you there are sometimes you will find solutions which will end up complicating the problem even more. So that's the Cobra effect, where you find a solution which creates a larger problem than the original problem. Now, see, on the other hand, again, it's a classic anecdote which is used very many times, and I'm sure a whole lot of you might have already seen it floating around on WhatsApp. There's this young, dynamic chap who's arrested for national activities, almost like a terrorist, and he's in jail. And the father has been, a man of principles, and he's deeply pained by what his son has done because he's in jail and he doesn't know what the problem of the son is. And he always thought that the son was very bright and very courageous. But what has happened? So in deep pain, he writes a letter to his son one cold winter morning that, son, I've got old, and I've got so old that, when I went to my backyard to plow the small farm that we have to grow potatoes, I couldn't do that because I do not have energy anymore to do that. And how I wished you were with me. You could have then done this work and you would have had a crop for us. And he writes that letter. And then, the letter goes in at its normal speed, but, telegram comes back immediately. And it's virtually, reprimanding the father. That, father, what the hell are you doing? Please don't dig up the ground behind our home, because that's where I've hidden all the weapons and all the contraband goods. Please don't do it ever. Don't you know that this is important for me? Just leave aside your farm. Well, the father is heartbroken, as you would understand. that it is not just that the son has gone vagabond, but he's, completely disowned me. Barely had he read the telegram, he found a whole lot of army walking in and suddenly digging up the farm at the backyard, because they had obviously intercepted the telegram and seen what was written in. And yes, when they dug up the whole farm and they found nothing there. So then, the father contacted the boy that, you sent that letter and army came in, and, everybody thought that we are the worst people around in the colony. And then nothing came up. What happened? So then he wrote back at his leisure, Father, I know there was nothing, I've done nothing wrong, but this was the only way sitting here I could help you and help you dig up the farm. So, where you want to find a solution, you will end up finding a solution. And you will use your complicated situation also to simplify and find a solution. So I've told you two very completely contrasting stories, where one, the solution looked very simple and it ended up creating a larger problem. And the other one, where you virtually had no hope for a solution and the chap ended up finding a solution. Of course, in both, I'm not going into the morality of any of the issues, but it's only to sort of to show that how things can come up, how you address complexity, and how you create complexity. In real world, in the legal world, a lot of it's a very popular area of work today is arbitrations. And if you go back to a little history of arbitration, currently arbitration is for every civil dispute, there's an option of an arbitration and you can go in an arbitration. To begin with, what was an arbitration? It was essentially an alternate to someone going in, not to the court, but get the matter settled by an expert in the field in which the problem had arisen. So if you were running a textile industry, you would go to a textile expert and get your matter settled. And as we all of us know, that civil matters in court get decided on the basis of the rule of law, and there is no place of equity in it. It's by strict law. So even if you are equitable and you are, being sort of shortchanged, but if on the strict law the other side is right, it is right. And that is how the courts are supposed to deliver what to adjudicate on civil disputes. On the other hand, you went to arbitrations where the industry expert would see the background, would understand what the trade practice is, see what the equitable thing is, see how the transaction panned out, and gave in sort of a solution basis that. So it was more equity as against the strict law. And that is why they were not really men of law, but they were men of industry. But fast forward it today, you made a law which says that the arbitrator has to decide in accordance with law, which means his ability to decide on equity is gone, taken away. And the arbitrator has to be alive to what the written law is, what the judgments are, and what the legal position is. See what the situation is. Today, somebody who's not a registered lawyer in India cannot even advise on Indian law, leave alone practice law. But somebody who's not a lawyer can be an arbitrator and adjudicate and give judgments. Now, what has happened is the purpose of arbitration is taken away by creating a complex mechanism, because you found that some people were taking advantage of the situation. Now, because some people were taking advantage, you have created a barrier for the whole industry. Now, the arbitration, if they are to be as strict as per strict law as courts, then why arbitration at all? The only reason is that the process is much simplified than going to a civil court. Then the question is, and that is where you have to go back to the roots and see simply what the problem is. Then the problem is not the forum, not the law, but the process. So you simplify the process. If you could simplify the process for arbitrations and get quick results, do the same for the civil courts. You can't blame the civil courts for being very slow and very archaic when you saddle them with such complex procedural law. And on the other hand, you're comparing them with arbitrations who are not saddled with such procedural law. And that is why it's another principle that we normally, read and sort of study, is the principle of form over substance, or substance over form. What is more desirable? It's always substance over form which is more desirable. But in creating procedural complexities, we have sort of led to a process dominating the substance. And that has been again a problem in both our procedural laws, civil as well as criminal. And as young lawyers, when you walk out into the profession, the first thing that hits you is that even if you understood the problem, how to find and navigate the processes to do the filing, to get the get the matter up on board, conduct the trial, get results, file appeals, go to high court, go to the Supreme Court. The whole process that is undertaken, those complications will always come in, but please always remember those are all procedural complications. That is our foremost job. I've so far spoken on what ought to be, but now let me come to of what is. Today, even if we are talking of what ought to be, the fact of the matter is that we are living with such complex procedural stuff. So, as a lawyer, you will have to navigate through them. It's your responsibility that you navigate through that complex procedures, instead of let the citizen face the brunt of the same, and you will be able to find solution. If you can't, it's always okay to say that I do not know the answer. Let me ask someone, or let me try and find it out. Instead of first going headlong into the court and then figuring out that what we undertook was incorrect. Also, it should always sort of our endeavor should be to first understand it simply and find the simplest remedy first and then the complex one. Vinitji, let me know what the time is. Do we have time, or do we move on to Q&A? I'm okay either which ways.
Sir, we have a few questions so far, so you
Let's
can
take
decide.
them. Can I see them, or do
Yes,
I,
sir.
or somebody will be talking?
Yes, sir. I can see them on YouTube.
Okay. Oh, sorry. On my meeting, this chat, I don't have the questions. So why
No,
don't you?
sir. It won't be visible on the chat, but I can see them on the YouTube chat section.
Oh,
Do you want me to read this over to you, or should I share? Okay, I'll just read this over and I'll also
I'm not
share.
on YouTube right now. Do you want me to open? Because I don't have the YouTube link, I believe.
All right, sir. Sir, this the link is shared in the chat box.
Fantastic. Okay. I will let me. So do I just click it on? Yes, the link is
Yes, sir.
there. Let
Yes,
me
sir.
just click it on
Yes,
and open it.
yes, sir.
Uh,
So I can also read the questions over to the audience so that people can
sure.
follow the questions, right?
Yes.
All right, sir. The first question is from Abhay. He's asking, sir, despite remedy delay of justice is inevitable, how can an ordinary citizen deal with that?
Abhay, you asked a question which probably nobody in the country has been able to answer or find a solution to, yet. It's a sad situation, tragic situation, I would say, but nonetheless, that is there. Now, how an ordinary citizen can deal with it? Let me, I always, when I'm talking to people who interact with me, I always say that, there is one thing about being right or wrong. Most court things are not about right or wrong, but they're about perspectives. And when you do a cost benefit analysis, always include the cost of time, energy, uncertainty, that is there in the when you head in for a litigation. And if you do that exercise, a lot of times you will find an amicable settlement that is that is sort of not just good for the litigant, but he's also happy with it. Most often, we are not able to do that cost benefit analysis. Now, I am not for a minute saying that even if somebody has been wronged tremendously, has to always go in for settlement. I'm only saying that given the realistic situation of delays that do happen, and we can't shy away from the fact that they do happen, we also need to find a solution for a client. Not we are not just to fight for his cases, but also to find solution for him, getting relief for him. That's, I think, should be the prime importance. And that is A. B, there would be a lot of things that can be done to speed up things. A, we have to be very diligent as lawyers so that we are not slack. We don't get into the sort of a routine of adjournments, etc. A lot of matters get pushed away because there is lack of preparation by the lawyers. I think that shouldn't happen. A lot of times we just sort of start thinking on the matter when the matter is there in court or just before that. I think we have to, get into the habit of being fully prepared. I mean, there's some of the pointers which are difficult, for the citizen, I can only sympathize with, but I think the citizen also at some point of time has to raise his voice that the state needs to build a robust judicial system in terms of infrastructure. Today the judicial system is completely struggling with infrastructure. If less than half the judges work, you can't expect them to deliver entire results. Also, let me we all talk of delays, but and it is always said that justice delayed is justice denied, but there's an equally important counter to it which says that justice hurried is justice buried. So very quick turnaround could be as disastrous as a slow turnaround. I mean, I can only sort of talk on that. It's definitely a very difficult question to answer, but very, very important and very pertinent.
Yes, sir. And secondly, we have a question from Sonakshi. Uh,
Yes.
yes. Sir, she has written that it's a delight to hear from you after a long. I already in touch with you. My question is, how can we scrutiny facts which overlaps in different laws? For instance, consumer cases.
Thank you, Sonakshi. Good to reconnect. And yes, this is something which you're going to find day in and day out. As transactions and human relationships get more and more complex, you will find that most things overlap between different subjects, different jurisdictions, and different people who are involved in it. So obviously, I think the best way is to use the method of rationality and logic. We are all taught logic at some point or the other, how math or how you do equations, that you go one by one. Read one, read the other, and see its interplay, and then you will find the connect. The first thing that is required is to find a connect. Once you connected the two things, you will know how it ought to pan out. And you will also need to understand what is the dominating position, if at all there is one between the two. What is the critical thing between the two? I don't know if some of you have got a sort of background of finance, but when we talk of finance and we study finance and we do decision making in finance and economics, the decision making always hinges on the critical resource, the resource which is the least available or the most scarce. And that is the most critical for you, and you work backwards from that. So, even in law, when you've got multiple issues, multiple subjects, you have to devise your methodology and logic, how you move from one to the other. Because if you're going to get confused between them, then you are in trouble. So I think the methodology of logic and rationality is best. You go step by step, understand the two things and the connect between them, and then go ahead.
That's a really good approach, sir. We can have the next question. That is also from Sonakshi. It's a very long question. In fact, in the follow-up of the same, based on foregoing pandemic distress, there have been the cases where people went to consumer courts, and due to legal complexities, the cases couldn't be entertained. And the follow-up question is: Are medical practitioners could be questioned under consumer courts for services they render? Likewise, many cases of companies sued under the act didn't get recognition in spite they do render service. So kindly enlighten her, sir, on these questions.
So I don't think that the cases got sort of thrown out because of the complexities. You may say that because of the complexities involved, they were not thought to be, was difficult for people to understand. But eventually, the courts will entertain and not entertain basis A, whether they have the jurisdiction to hear those, B, whether they are convinced with your case or not. The second part, of course, being the merits of your case, but the first part being the jurisdiction and the authority of the tribunal. Now, if there has been an incorrect understanding, then of course you have a remedy of appeal that is available to you. If it is not because of any lack of understanding or incorrect application of law, but because they say that in such circumstances the jurisdiction of the consumer court is not there, because consumer court is very focused and only for a single purpose. If there are multiple issues involved, and some of them may not be in the realm of the power of the consumer court, they will have no option but to let it go and ask you to go to a civil court, which will have all the powers. I'm assuming that they are there. And your second part was medical practitioners could be questioned for services they render. Likewise, many cases of companies sued under this act didn't get recognition in spite they do render services. Now, this is again depends on the perception. Your perception may be that they are rendering services, and another's perception could be that they're not rendering services. At the end of the day, it's a question of interpretation, which the courts will have to decide. And once they decide one thing, it will be applicable for all. A classic debate has always been yours and my profession, the legal profession, whether it's a service or it's a noble profession. And there will be arguments on both sides endlessly, and you really can't come to a conclusion that whether at the end of the day we are a service industry, or we still live in the old world charm of it being a noble profession. But even if it's a noble profession, it is to what end? So those issues will always be there, and that is why it's always challenging to be a lawyer, and it is always very satisfying, because you end up trying to simplify the complexities, and once you're able to simplify and make everyone understand, you get the solution for the problem that is in front of you. So that's the uh, thing on that. I can see the next question.
Yes,
Yeah, Beneath, can you just go ahead with that?
yes, sir. So the next question is that the judicial systems of UK, USA are far more layered and complex in comparison to India. Why India is still lagging behind in this area?
I think I don't know if that's a great way of seeing the situation. More complexity and more layering does not necessarily mean better. Just like in some things complexity is desirable, in some things it's the simplicity which is desirable, and more often than not it's the simplicity which you aim at. The more simpler the solution is, the better it is. Only that it's become fashionable to find a complex solution. It sounds more glamorous, but actually in the real world it is not. What can be achieved? We classically say that what can be achieved by guns. Why should you use cannons for the same? What can be achieved by a sword? Why should you use guns for that? What can be achieved by discussions? Why would you even want a sword for that? And if something can be achieved by silence, why would you even want words for it? So if there's a simple solution, why would you want a complexity? Also, I'm not sure if the judicial systems of UK or USA are more layered and more complex. I'm not sure and convinced with that, because India is equally layered. You've got at least so many layers of judicial redressal mechanism itself, and some of them are parallel and not just layers. So you've got India is actually sort of a middle path. We are not even the trigonal mechanism of the continental Europe, nor the complete now the court system which we originally wore of the original common law system. And so you've got mufassal courts, and then civil courts, then you'll have district courts and high court and supreme court. That's one only layer. Then you have revenue courts which are parallel, and which will also eventually merge. They'll have revenue boards and they'll merge into the high court in terms of the hierarchy. You've got multiple tribunals, each one, some are state level, some are central level. You would have various government bodies which are created by the government for redressal mechanism, multiple layers, and that's what I had spoken of. You've got so many options which people had. So coming back to it, I'm not sure if a more layered and a more complex system is better. B, I'm also not sure if the American and the UK systems are more layered and complex than in India. And I don't think a more complexity is a desirable, goal. I think more simplicity is a desirable goal. We shouldn't go into the reverse mechanism. At the end of the day, as a citizen, I'm only concerned with my redressal, and not if you found a very complicated legal document to see. 50 years ago, everybody used in North India, they used language which today you and me don't even understand. Imagine if we are stuck to that language we can't understand, forget about the citizens. Why should the citizen be forced upon a complex system which he can't understand? Because at the end of the day, the judicial system is not meant for the lawyers and judges, it's meant for the citizens. We must understand that. Yeah. Can we take the next one?
Sure, sir. Sir, after the COVID-19 situation, many legal proceedings adopted virtual platform for convenience. Can you see this trend in legal profession as innovation and hope it may can easy the traditional complicities?
Absolutely. I mean, this is a good. I mean, as we say, you must always find an opportunity in trouble. That's what an enterprise and an entrepreneur's. That's the only distinguishing sign of an entrepreneur. That an entrepreneur finds an opportunity in problem. So COVID-19 has been a huge problem for everyone. But imagine you can find opportunity, and the legal system has been offered an opportunity that it can actually fast track the shift to technology. In fact, across the world, the legal system was always accused of being the last to adopt technology and being very resistant to adopting technology. And we should change that image of ours. And it's again a golden opportunity. Why should we let it go? At the end of the day, virtual hearings is just one of the things, but there's so many other technology assistance that we can find. The earlier we adopt, the better it is. Why should technology not aid us like it is it's an aid of everywhere else? I think that's an opportunity that we must seize. We should train ourselves, and we should make things which will make it easier for everyone, including the person for whom the whole judicial system is designed.
Yes, sir. Sir, do you have any advice for budding lawyers, legal practitioners, advocates,
You
consultants?
know, I'm as much a student as all of you. The day you stop being a student, you stop learning. So I think, all I can share is my own experience, that I see myself as a student even now. Every minute is something to be learned, and see it open, with an open mind. And I hope we continue that ways. Yes, of course. Um, uh, ancillary benefit of the same is that you also remain young in your thought process. So I think that's what I can share with. I don't see anything else. They're all such bright people. They possibly know more than we all did when we were out of college. And it's always best to chart your own territory, forge your own path, rather than being sort of given an advice to go on a path or not. All I can say is just continue being a student, so you're learning and creating your own path, always, forever, until your last breath.
Indeed, sir. Thank you so much, sir. Towards the end of the session, we would like to request our head of department, Dr. Mili Chopra, if she would like to uh, say any closing words.
Hello, hello. Beneath, there are otherwise certain connectivity issues. Anyways, so sir, that had been an opportunity and privilege for all our students and even for the faculty members to hear to your views. And actually, I am quite thoughtful about the process. That is, once we are talking about the simplification, why don't we opt for that? Why to look forward for some person else? Like the system itself, be you can say like it should be for the convenience of the people and not for the hurdles itself. And thank you so much for your enlightenment. And I think from this particular perspective, the young lawyers should be inculcating a new thought over there, like how to make the things simpler and how to evolve new processes, new ways over there, so that the world could be made as a best place to live in. With all these words, thank you so much, sir. And it had been a pleasure to be there with you. And probably in the coming future, once the university is open and we are physically being there in the university, we shall be able to see you in the campus very soon.
Absolutely, it'll be my delight. I'll be
Thank you
very,
so much.
very happy to come in. Thank you.
Thank you so much, sir. Thank you.
Uh, to end this session, we can quote Leonardo da Vinci, who said that simplicity is the ultimate sophistication. With these ending words, sir, thank you so much for being here. The audience is highly enlightened with your presence, and we look forward to having you again. Thank you, sir.
Thank you. Thank you so much. Pleasure being with you.
Sanjay, should I turn this off?